Okay, good evening, friends. It's time, and we can start our webinar on decided cases on IBC, recent decided cases. We have with us Mr. Devang Thakkar, a seasoned professional with 30 years experience in finance, secretarial compliance, and corporate legal consultancy. He is a BSc Diploma in System Management and from NMIMS and Mumbai University. He is a member of ICSI. He is an independent director and insolvency professional and registered valuer. He worked with various industries since years, and now he runs his own practice with in corporate governance, restructuring, and compliance. Further, he is a visiting faculty at NMIMS, IAS, IBS, teaching finance and business laws. Welcome, Mr. Devan. Mr. Devarajan is not, he may join later. He got busy with his other assignment. So due to time paucity, we'll start our presentation. Welcome, Mr. Devan. We'll start our presentation, right?
Yeah, thank you.
Yeah, Mr. Hegel, please start.
So good evening, everyone. Today I, Higriv Kumar, will be presenting on notable cases pertaining to NCLT judgments as well as the proceedings of the Disciplinary Committee. So starting with the first case of today, that is Habiba Resource Private Limited versus Vidyut Metallic Private Limited, decided by the NCLAT New Delhi on 1st September 2025. The fact of the case is as follows. Habiba Resource supplied goods to the Vidyut Metallic and dispute were referred to the MSME Facilitation Council, which passed order in 2011 in favor of Habiba. The corporate debtor challenged this award before the City Civil Court, Hyderabad, but the petitions were dismissed in 2012. The matter went up to the Andhra Pradesh High Court, which was also dismissed the appeal in 2013. A further appeal was made to the Supreme Court was withdrawn in March 2013. Thus, the MSME awards became final and binding in 2013. However, the debt failed to pay. Almost 9 years later, Habiba Resource issued a Section 8 demand notice in December 2019 and filed a Section 9 application before the NCLT Mumbai. The NCLT Mumbai rejected the application on 21st of March 2025 as time barred under the Limitation Act, and Habiba Resource appealed this to the NCLAT Delhi. So basically, in this case, there were three issues which were raised. The first one was, which we can see in the screen, that whether the Section 9 application filed in 2022 on awards finalized in 2013 was within limitation period. Second was whether issuance of a Section 8 IBC notice in 2019 could revive or extend limitation. And the third was whether Article 136, 2 years of degree execution, or Article 137, 3 years of right to sue, appeal to Section 9 IBC application. Now moving towards the arguments of both the parties, starting with the arguments of the appellant, which was the Habiba Resource, which was the operational creditor. The arbitral award determined the debt, and since the Section 8 notice was issued in 2019, the Section 9 application in 2022 should be treated as a within limitation. They argued that the limitation should run from the date of the default after Section 8 notice was served, not from the arbitral award. They also contended that
default date, when they are telling run from default, limitation.
They are saying that the limitation should be started when the Section 8 notice was served.
I know, but okay, after Section 8, they defaulted, from there you come. Okay.
They also contended that an arbitral award is like a degree. So 12 year of limitation should not be applied there. So respondent, they argued in response to the argument, the right to sue occurred when the award became final in March 2013. So limitation expired in 2016. Section 8 notice cannot be revived a time bar debt, and IBC proceedings are not a substitute for degree execution. They relied on the Supreme Court ruling in BK Educational Services Private Limited versus Parag Gupta, an associate of 2018 judgment, which held that Article 137 governs the IBC applications. So moving to the tribunal's finding, the NCLT Mumbai laid the judgment that they held that the award became final in 2013. The Section 9 application filed in 2022 was beyond the 3 years limitation under Article 137, read with Section 238A of the IBC. they clarified that Article 136, 12 year of limitation, does not apply as IBC is not for a degree execution, and dismissed the Section 9 application as time barred. So the operational creditor, they went to the NCLAT principal bench. They held their judgment stating that they agreed with the NCLT and affirmed the order of the NCLT Mumbai, stated that a Section 8 notice is not only a condition precedent and cannot extend or restart limitation, and retarded that the right to sue arises when the debt becomes due and remain unpaid, which here was in 2013. Concluded that application was hopelessly time barred and dismissed the appeal, saying that this appeal lies under the Limitation Act. Moving towards the next case, which is of Kiran Kumar Jain versus Cosmo Cooperative Operative Bank Limited and another. So this case was decided by the NCLAT Principal Bench, New Delhi, on 2nd of September 2025. This case involves a personal guarantor, which is Mr. Kiran Kumar Jain, who challenged the admission of an insolvency application under Section 95 of the Insolvency and Bankruptcy Code 2016. The matter is not about the corporate debtor directly, but about the liability of the personal guarantor. So moving towards the fact of the case, the corporate debtor Dilip Chabaria Design Private Limited had availed credit facilities of around 44 crore from Cosmo Cooperative Operative Bank. On 2nd of March 2016, Mr. Kiran Kumar Jain executed a personal guarantee in favor of the bank. So the NCLT Mumbai admitted the bank's application under Section 95 against Mr. Jain after considering the resolution professional report under Section 99, which recommended admission, and Mr. Jain appealed this admission before the NCLAT. So in this matter, basically 5 issues was raised, which can be seen in on the slide. The first issue was that whether liability arises when no fresh disbursement occurred after signing of a guarantee. The second issue was that whether a guarantee can be enforced without invocation. The third issue was that whether pendency of DRT counterclaims bar Section 95 proceedings. The fourth issue was that whether creditor can proceed against one guarantor selectively. And the last issue which was raised in this case was whether insolvency proceeding can be withdrawn post-admission on private settlement. So moving to the next slide, which talk about the arguments made by both the party. So in this case, the appellant, which is Kiran Kumar Jain, was a personal guarantor. They argued that claiming that the guarantee was signed on the understanding that the fresh funds of rupees 44 crore would be disbursed, but no such fresh disbursement was made. Argued that since the guarantee was never involved, his liability has not arisen. Pointed out that he himself was the financial creditor of the corporate debtor, which claims of 95 crore, so his liability could not be crystallized. Moving forward, they responded, which is the Cosmo Cooperative Bank. In response of the argument of the appellant, they argued that they submitted that the guarantee deed clearly covered both fresh and existing facilities, which was rupees 22 crore term loan, rupees 21 crore cash and credit, and 1 crore of letter of credit. The loan agreement of the same dated showed repayment beginning on 4th of March 2016, which proved that disbursement had already taken place. Notices under SURFACI Act and callback notices had been served, providing invocation of the guarantee. It stressed that DRT proceedings and IBC proceedings are separate remedies and one does not bar on the other. So in this case, so the judgment which was given by the tribunal was that first, the NCLAT finding on the 2nd of September 2025, they held that the personal guarantor on 2nd March 2016 covering exceeding credit facility, not just fresh funding, the repayment schedule beginning immediately after execution of the guarantee, confirmed that loans were already disbursed and rejected the argument that the absence of fresh disbursement freed the guarantor from liability, and clarified that pendency of a cases before DRT does not prevent insolvency proceedings under the IBC. Also held that the creditor may proceed against any one or more guarantor and its discretion. So in this case, there was a settlement which says that during appeal, Mr. Jain and the bank entered into a settlement on 1st of August 2025, where Mr. Jain agreed to pay rupees 15 crore in installments and the bank agreed to discharge his guarantee. The NCLAT, however, clarified that since the Section 95 application had already been admitted, withdrawal requires compliance with Rule 11 of the IBC rule of the personal guarantee 2019, that is consent of 90% of creditors, and directed the resolution professional to publish the creditor list and place the matter before NCLT from withdrawal if the consent is obtained from both the party. Moving to the third case, which is Kela Financial Corporation versus Bharat Chandran. This judgment was given by the NCLT Kochi bench. Of the case is as follow. The corporate debtor here was Trivandrum International Health Services Ltd, which has taken loans from various institutions. In account became an NP of in 2015, and the company was admitted into insolvency under Section 7 of IBC on 7th of February 2020. Since no resolution plan was approved, liquidation was ordered on 2nd of June 2022, and Kerala Financial Corporation, which is KFC, had an admitted claim of about rupees 61 crore. Later, the businesses was sold as a going concern in December 2023, and KFC received only partial payment from the liquidation proceedings. Meanwhile, the promoters of the company, Dr. Bharat Chandran and Dr. Aslama Nair, had given personal guarantees. Insolvency proceeding against them were instant under Section 95 IBC as an instance of Dhanlakshmi Bank. The guarantors failed to submit any repayment plan. So, by order dated 21st of December 2023, NCLT allowed creditor or the debtor themselves for a bankruptcy under the Section 121 of IBC. So, the KFC then filed bankruptcy application against the guarantor on 4th of March 2025. But this was well beyond the 3-month period allowed under Section 121 Clause 2. So, the key question was whether the delay could be contained or not. So in this case, there was basically three issues which was raised. That first was that whether KFC's bankruptcy application against personal guarantors was barred from the limitation period, limitation of 121 clause 2 of IBC. The second was that whether delay beyond 3 months could be condoned under Section 5 of the Limitation Act, read with Section 238A of IBC. And the third issue in this was case whether pendency of liquidation and moratorium justified KFC's delay. Moving towards the arguments which was made by both the party, the Kerala Financial Corporation, which is KFC, was appellant in this matter, applicant. They said that it was entitled to initiate bankruptcy since its claimant remained unpaid. Their delay was not intentional but happened because liquidation was going on and they were waiting to see what amount they would have been receiving. Being a statutory body, it also needed administrative approvals before filing, and argued that since Section 238A applies Limitation Act provisions, can be sued and delays can be condemned under Section 5. And they relied on the cases such as Shesh Nath Singh 2021 and BK Educational Services of 2018, which emphasized a liberal approach to the limitation under IBC. The arguments which were made by the respondent, in this case, that was a personal guarantor, they objectively strongly saying the application was hopelessly delayed. Section 121 clause 2 required filing within 3 months from 21st of December 2023, which meant the last date was 20th of March 2024, and KFC filed only on the 4th March 2025, which is almost a year late. Claim that Section 121 is timeless in mandatory and they cannot be condoned. Pointed out that even the resolution professional report was filed very late, making the whole process defective. Moving towards the judgment which was given by the NCLT Kochi, the tribunal noted that Section 121 clause 2 uses the word shall, but it does not give any penalty for delay. And relying on the principles from the earlier Supreme Court cases like Babu Ram Upadhyay of 1961 and Topline Shoe of 2002, it said that sometimes even timelines that look mandatory may be treated as a directory, specifically if strict enforcement would cause injustice. It contended that the delay under Section 5 of the Limitation Act, while Section 238 of the IBC, but imposed cost of rupees 25,000 per case to be distributed in the National Defence Fund, and directed the Kerala Financial Corporation to file proof of compliance and allowance and bankruptcy proceedings against the guarantor to be moved forward. So this case basically clarified that even though the IBC has strict timelines, the 3 months period under Section 121 Clause 2 for filing bankruptcy against personal guarantor is directly not mandatory. Delay can be condoned under Section 5 of the Limitation Act, but only in exceptional cases. Moving towards the next case, which is Devi Engineering and Construction Private Limited versus Global Industries and others, decided by the NCLAT Chennai bench in 2025. This case is about a corporate debtor, Devi Engineering and Construction Private Limited, and it deals with the questions of whether multiple insolvency petitions can proceed against the same company at the same time. So the fact of the case is as follow. The corporate debtor, Devi Engineering and Construction Private Limited, had several creditors who filed insolvency petitions against them. And Global Enterprises, an operational creditor, filed a petition under Section 9 of the IBC before the NCLT Amravati on 7th of July 2025. The NCLT admitted this petition, consumed CRP, and appointed an interim resolutioner professional. And around the same time, another creditor filed a separate petition under Section 7 of the IBC. In this case, the corporate debtor also filed a recall application challenging the admission. However, since CRP had already been submitted in the first petition, the NCLT closed the second petition as insufficient and did not entertain the recall plea separately. And the corporate debtor then appealed to the NCLAT, arguing that its recall application should have been decided on merit and not dismissed summarily. And moving to the issue of this case, so basically in this case there was a three issue which was, the first was that whether NCLT was justified in closing company petition IB number 1 clause 7 AMR clause 2025 as infructuous after CRP had already been initiated. The second issue is that whether the corporate debtor recalls application should have been adjudicated independently despite another petition being admitted. And the third issue is that whether multiple insolvency proceedings can run simultaneously against the same corporate debtor. Moving towards the arguments which was made by both the party, the appellant, which was corporate debtor, Devi Engineering and Construction Private Limited, they said that NCLT wrongly closed the second petition without deciding the recall application on merit. This deprived the company of a fair chance to contest allegation and challenge the admission order. Each petition and recall application accordingly to them should have been heard independently. And in response to this, the respondent, they made an argument that once CRP was admitted in the first petition, the insolvency of the company was already established. And creditors must now file the claims through the CRP process, not through the parallel petitions. And allowing multiple CRPs would cause confusion and duplication and procedural queries. Therefore, the recall of application automatically became a necessary thing. So moving towards the judgment given by both the tribunals, the first one judgment was given by the NCLT Amravati, which admitted the first petition under Section 9 on 7th of July 2025 and started the CRPC process, closed the second petition as infructuous and declined to separately decide the recall application. So in this, the NCLAT Chennai, they affirmed the NCLT decision and held that once CRP is admitted, no petition, all other petitions became infructuous with the whether under Section 7 or Section 9 of the IBC, and found no illegality in NCLT's approach, since admitting multiple CRP against the same debtor is not allowed under the IBC, rejected the corporate debtor appeal, and clarified that its remedies now lie within the CRP process itself and not in a parallel proceedings. So the NCLAT reinforced a key principle: only one CRP can run against a corporate debtor at a time, and once CRP is admitted in one case, all other insolvency petitions automatically becomes infructuous. The corporate debtor grievances must be addressed within the ongoing CRP, not through the separate challenges or separate petitions. Moving to the next case, which is of Expert Reality Professionals Private Limited versus Logic Infrastructure Private Limited and other, NCLAT, on 8th of September 2025. This case involves the corporate debtor Logic Infrastructure Private Limited, and the question was whether the insolvency petition filed under Section 7 of the IBC was a genuine financial debt or a collusive and fraudulent proceedings. Now moving towards the fact of the case, the Logic Infrastructure was developing a real estate project called the Blossom County, which faced huge delays and financial troubles. And in October 2020, Logic entered into an MOU with Expert Reality Professional Private Limited for a buyback agreement. Based on this, Expert Reality issued around 15 crore between 2020 and 2021. And later minutes of a meeting in December 2021 recorded that Logic owned crore and 80 lakhs crore to Expert Reality, payable in 1 month within 18% of interest for delay. With Logic did not pay, Expert Reality filed a Section 79 petition before the NCLT on 14th of July 2023 and NCLT admitted the petition and started the CRP proceeding. And soon home buyers and unit owners objected under Section 65 of the IBC, alleging that the insolvency case was collusive and fraudulent to the protect Logic from its liabilities. And in this case, there were three issues which was raised. The first issue was that whether the Section 7 petition was based on a genuine financial debt or it was a collusive arrangement. Second was that whether reality party links and fabricated documents amounted to the fraudulent initiation of CRP. And the third issue was that can NCLT recall its admission order if CRP is initiated with malified intention. Moving toward the argument of both the party, the appellant, which was the Expert Reality Professional Private Limited, they made an argument. They claimed that the petition was genuine and based on a valid agreement and argued that related party statute alone does not prove fraud, and said that objection were an afterthought filed month after the admission of CRP, and alleged that NCLT has effectively reviewed its earlier orders, which is not allowed. Moving towards the respondent, they argued that they said that the Section 7 petition was a shame designed to misuse the IBC, and pointed out that directors of Expert Reality and Logic were closely connected, showing collusion. Highlighted that financial statement treated the money as an investment, not loans, and liability was even reduced to the nil later. Moving towards the judgment of the NCLT and NCLAT, the NCLT on 6th of February 2025, they found a strong evidence of collusion between Logic and Expert Reality and held that the so-called loan was not an arm's length financial debt but a device to misissue the IBC, and dismissed the Section 7 petition, recalled the admission order, and imposed a 55 lakh penalty under Section 65 of fraudulent filing. The NCLAT on 8 September 2025, they upheld the NCLT findings and retorted that the fraud vitiate all proceedings and insolvency cannot be issued or for fraudulent or collusive purpose. Noted common management links, inconsistent financial records, and the corporate debtor suspiciously easy admission of liability as clear sign of collusion. The NCLAT clarified that insolvency proceedings under the IBC must be genuine and for resolution, not to shield debtor or through collusions. And fraudulent or collusive petition can be dismissed at any stage, even after CRPC admission. And the penalty of rupees 55 lakh was imposed by the NCLT on the appellant remained valid. Moving to the next case, we talk about the.
This is Devang, this is very interesting. NCLT has gone far ahead.
Moving towards the next case, which talk about Small Industries Development Bank of India versus the Punjab National Bank and others, decided by the NCLAT Delhi on 8th of September 2025. This case is about the corporate debtor Swatviki Proteins Private Limited, and the dispute was raised by a financial creditor, SIDBI, regarding a distribution of resolution proceeds. Moving towards the fact of the case, Satvik Proteins Private Limited went into insolvency, and a resolution plan was approved by the Committee of Creditors and later by the NCLT Jaipur bench on 12th of March 2024. And Punjab National Bank held that majority voting share of 96.68%, while SIDBI had only 3.22% voting share. And SIDBI claimed it was a secure creditor and wanted distribution of resolution process in proportion to the value of its security interest over the plant and machinery. However, the COC decided that the distribution would be on the basis of voting share, not on a security value. SIDBI filed an application before the NCLT in November 2023, but it was dismissed later on 13th of June 2025 after the plan had already been approved. So in this case, there was three issues which was raised. The first issue was that whether distribution of proceedings should be based on security interest or voting share. The second issue was that whether minority creditors' right can be overridden by the COC majority. And the third issue is that what is the scope of judicial review over a committee of creditor commercial decision.
Both
Moving
CDB
towards the
and 1 minute. Both CDB and PNB both were secured creditors. Both
Both were
CDB.
secured creditors. SIDBI also was a secured creditors or unsecured creditor or the second charge.
This in the
SIDBI was
of
a secure
facts,
creditor.
CDB
And
was
what was the
secured
charge?
creditor. And PNB
was-
also, this banker, PNB was also secured creditor. Both were secured creditor.
Yes, ma'am.
Okay, because you have written for SIDBI secured financial creditor, for PNB you have just written dominant creditor, so that's why we are. So PNB is also secured financial creditor.
Yeah, but they have a majority of voting share.
Yeah, but majority voting share was PNB and CDB was 3.22. That is the scene, right?
Moving toward the argument of the party, the appellant, they claim that being a secure creditor, that is SIDBI, it should get priority distribution proportional to its security interest, not just its voting share, and said that ignoring security undermined equitable treatment of creditor under section 30 clause 2 of IBC, and argued that its objections were raised before plan approval by NCLT never considered them, and stressed that a minority voting power should not be erase its security rights. The respondent, they defended the COC's decision, saying it was taken in its commercial wisdom, and pointed out that once a plan is approved and implemented, it cannot be reopened for a minority creditor, and relied on the Supreme Court judgment of Reassurance ARC versus Amit Mythicals of 2021, which held that COC's decision on distribution cannot be questioned as long as the section 30 clause 2 is followed, and also cited SBI versus IDBI Bank 2025 NCLAT judgment, where pro rata distribution was held valid. Moving towards the judgment of the NCLT and NCLAT. So the tribunal upheld the NCLAT, which upheld the NCLT's order and dismissed the SIDBI appeal. And it said that although SIDBI was a secure creditor, its voting share was only 3.22%, and the COC had decided distribution collectively, such as a commercial decision of the COC cannot be interfered by the tribunal, and reaffirmed that the law laid down in the Amit Mythical's case is binding until the Supreme Court decides otherwise. In the pending DBS Bank versus Ruchi Soya appeal, the tribunal acknowledged the SIDBI grievances but held that finality of approved plan cannot be disturbed. The NCLAT concluded that distribution under a resolution plan is a matter of COC's commercial wisdom, and even secure creditor cannot demand distribution based solely on security value if the COC has decided otherwise.
Interesting.
Moving towards the next case, which is
It
of
also depends on what is the charge filed.
Yeah,
with
also,
ROC.
Devang, in resolution plan only they have written that distribution will be like this of that. And that was approved by majority. Even resolution.
The
plan-
majority rules applies.
That way they have done. It is not liquidation, it is resolution plan. Resolution plan, commercial wisdom. They will not enter.
That's true.
yes,
See, here actually the commercial wisdom has actually won the
Oh, you are
day.
there. Yeah.
Yeah, I'm there right from the beginning.
Arre, we
That's the
waited.
entire trust of IBC.
No.
Actually. Yeah, sorry, Mr. Devaraj.
I've been listening to Mr. Sharma for a long while.
Oh, I see. Oh, sorry.
I thought he's presenting it, then we'll have possibly question answer sessions or whatever it is. But
Yeah.
here in this, what we need to understand is that when a COC distribution happens, right? The SRA prepares a plan. There is section 30 subsection 4,
Mm.
which is the basis for what we call as equitable distribution.
Mm.
Right? Now, the equitable distribution there they are referring to is the intra-C distribution. Like, for example, if there are two secured creditors, you are providing 10%, then you cannot say, I will give 10% to one secured, the other fellow will give 5%. So intra-C, there cannot be a problem. The inter-C distribution, there is no issue. Now, in this case, if SIDBI has gone there, they are saying security means I'm sure possibly Punjab National Bank is unsecured. It is possible, I don't know. Right? Otherwise, there is no reason for SIDBI to have gone.
Yeah.
Right? Okay, one. So we need to check that detailed order. The second point is that technically, when you're talking about distribution, we have done so many resolution plans, you know, that when we do the classification and the arrangement, the SRA does, we discuss with him. SRA gives a plan. Ultimately, COC can say you distribute this way. Right? For him, he says, ये सामान है, मैं इतना पैसा दूंगा. SRA says. Now, and he tells us, you distribute yourself, whichever way you want. I have no issues. Right? But I will not pay you more than this. So now, when there are secured creditors, you will give the same percentage. Here, what could have happened is that PNB being majority, they may have been unsecured. Since their vote is what will finalize, they would have said कि भाई मुझे इतना दो, सेबी को इतना ही दो.
Yeah, वो प्लान में ही डलवा दिया उसने.
And what could have happened is that because of that, the NCLT is constrained because commercial wisdom comes into play. Now the question is something like this. This is something that needs to be addressed in that sense. There is an issue here. You cannot have a situation that a secured creditor will get less than the unsecured creditor in terms of percentage. That's
Yes,
being
you're
fair.
not, sir.
You understand
Devati-
in liquidation you can understand. With all secured creditors are classified as one.
Hmm.
And unsecured is below in the waterfall mechanism. But technically, in claims, when we are classifying, even in the LOC list of creditors we file separately secured, unsecured. We mention it. Because secured status in terms of the security is higher. Now, here the commercial wisdom is what came into the picture. So the question is that the one question that we need to address is as an RP, whether the plan is compliant or not. Right? The RP nowhere here can say the plan is not compliant because feasibility viability is discussed. This much money is sufficient is held. Now, as far as who will be paid, how much is the discretion of the SRA, and the COC can say this is how it has to be paid, and COC decision is based on majority. That is where SIDBI did not succeed. So this
Sir, one
is
thing,
what is the
PNB
issue.
giving 96% as unsecured creditors is unbelievable. So we
That
need
is
to.
no. We
No.
don't know. We need to check that.
We don't know, so we have to check that fact
No,
also.
the value may be very small because SIDBI is in picture. It must be an SME company. The
MSM.
total exposure may not be a big amount, you know.
Right.
Yeah, the amount is not written, so I don't know. Amount is not written. What is the amount that has been disbursed? So we don't know. So it could be some amount which, see, SIDBI has a problem. They will give X amount for security. PNB would have given some unsecured loan, which have been of a higher amount, which falls into that bracket. अभी CGT SME में अगर आप disburse करते हो 2 crore तक आप you can give without any security. We don't know the total amount ना. सिर्फ भी 50 लाख दिया होगा या 2 crore दिया होगा ये भी हो सकता है. हाँ, we don't know. So check करना पड़ेगा.
The SIDBI has given equipment finance with specific charges also.
But that is fine. That is okay. But we don't know the quantum. See, for that, what is the difference? The quantum we don't know.
Yeah, Mr.
But in terms of fairness, there is an issue in terms of secured, unsecured,
Right.
which cannot be addressed because of the commercial wisdom issue.
Yeah, that exactly. They put in resolution plan, then they cannot.
Yes.
Moving on to the next case, which is Kotak Mahindra Bank versus Ashina FinCap Private Limited, decided by the NCLAT New Delhi bench on 9th of September 2025. This is a case between a financial creditor, which is Kotak Mahindra Bank, and the corporate debtor Ashina FinCap Private Limited. The fact of the case is as follows: that Kotak Mahindra Bank sanctioned a loan against property of 11.2 crores to the Ashina FinCap Private Limited on May 2024. The loan was a balance transfer from Yes Bank to Yes Bank, and Kotak directly paid rupees 11 crore to Yes Bank to close the old liability. The motorist property was supposed to remain security, but it was allegedly sold off to the third parties illegally in July and October 2024. From December 2024, EMI payment stopped and the bank issued a recall notice in January 2025 demanding a rupees 9 crore and 36 lakh. Kotak then filed a Section 7 IBC petition in February 2025 for initiation of CRP claiming default of about rupees 9 crore and 44 lakh. At the same time, the bank also filed a recovery application before the DRT Chandigarh. So in this case, basically there was four issue which was raised. The first was that whether the corporate debtor had committed a financial default under Section 7 of IBC, warranting admission of CRP. Second, whether disputed allegation of fraud, collusion, and a sale of mortgage property could be examined in summary of IBC proceeding. Third, whether pendency of parallel recovery proceedings before DRT barred initiation of insolvency proceedings under IBC. The third was that whether the last one was that whether part payment made under a one-time settlement negated the existence of a default on the date of filing. Properly sanctioned and agreements were executed and disbursal was made. Corporate debtor defaulted when EMI stopped in December 2024 and the recall notice was ignored, leaving an unpaid debt of more than 9 crore. And argued that under IBC, existence of default is enough for admission, citing Innovative Industries and Swiss Ribbons, said that IBC is for resolution of insolvency, not just recovery of security. The corporate debtor, they argued that the claimant that Kotak was misusing IBC as a recovery tool, said that the loan was vitiated because the mortgage property was sold off due to collusion between Yes Bank and Kotak, and pointed out that so there was no substituting default, alleged fraud and malafide intention behind the petition, and also argued that since Kotak had already gone to DRT, filing IBC was a forum shopping and relying on cases like Vidvarta Industries versus Axis Bank and Gilas Trust versus Byju's Ravindra, which held that IBC should not be used as a debt recovery forum. The judgment which was given by the NCLT New Delhi bench, the tribunal accepted that the financial debt did exist, but if noted that the fraud and collusion allegation involved complicated fact that could not be decided in summary insolvency proceedings, and it also observed that since part payment under OTS has been made, there was no clear default at time of the admission. The fact that the Kotak had also filed proceedings before the DRT showed forum shoppings, and the NCLT held that IBC is not a substitute for recovery proceedings. Its purpose is insolvency resolution, not enforcement of debt. Therefore, it dismissed the Section 7 application but allowed Kotak to continue recovery before other appropriate forum. The NCLT dismissed the Kotak Section 7 petition, ruling that a dispute allegation of fraud cannot be tried under IBC, and part payment under OTS meant there was no clear substantiating default, and filing in both IBC and DRT amounted to the forum shopping. Hence, the CRP was not admitted by the NCLT. Moving towards the next case, we talk about Ambience Airtech Private Limited versus Gorson High Tech Infrastructure Private Limited, decided by the NCLAT in 2025 on 10 September 2025. This is a case between an operational creditor, Ambience Airtech Private Limited, and a corporate debtor, Gorson's High Tech Infrastructure Private Limited. The fact of the case is as follows. The operational creditor filed a Section 9 IBC application before the NCLT to start CRP against the corporate debtor for unpaid operational dues. And on 11th March 2025, the NCLT pronounced an oral order in open court rejecting the application. The creditor then filed an appeal before the NCLAT, but only on 7th May 2025. Since Section 61 allows only 30 days plus 15 days condolence delay, the appeal was clearly beyond 45 days. The creditor asked for condonation of delay, arguing that the order was uploaded on the tribunal website only on 27th of March 2025, so limitation should run from that date. So in this case, there was two issues. First was that whether limitation under Section 61 clause 2 of IBC start from the date of pronouncement in open court in presence of both the counsel. The issue was that whether the limitation under Section 61 Clause 2 of IBC start from date of oral pronouncement in court, that is 11 March 2025, or date of uploading of the order on the tribunal portal, that is 27 of March 2025. Second issue is that whether the delay in filing the appeal beyond 30 days plus 15 days maximum condonable period could be condoned. Moving towards the argument made by the parties, the appellant, that which is the operational creditor, this made the argument that the said limitation should begin only from the 27th of March 2025 when the order was uploaded, and claimed the appeal was delayed by only 11 days, which could be condoned. Relied on the Supreme Court case Sanjay Pandruyag Kalate versus Vistra ITCL India of 2023, and also argued delay was not intentional but due to the short time and complexity of the matter. The respondent, in response of this, they said that the order was pronounced clearly on 11th March 2025 in open court in presence of both the parties. Hence, limitations started from that day. Pointed out that the creditor never applied for a certified copy, showing lacks of diligence, and distinguished the Kalate case, saying that was different because no substitutive order had been passed here, but here the rejection was final and complete. Moving to the judgment of the NCLAT, the NCLAT agreed with the corporate debtor. It held that since the final order rejecting the Section 9 petition was pronounced in open court on 11th March 2025, limitations start from that very date. Uploading of the order later did not extend the time limit. The appeal filed on 7th May 2025 was well beyond the maximum 45 days allowed under Section 61. Therefore, the delay condonation plea was dismissed and the appeal itself was also dismissed. Moving towards the next case, which is Vikram Bhavani Shankar Sharma versus Union Bank of India. This case was decided by the NCLAT Delhi on 11th of September 2025. This case was filed by the suspended director of the corporate debtor, Supreme Manur Wadia Infrastructure Private Limited, challenging the admission of a Section 7 IBC filed by the financial creditor, which is Union Bank of India. Moving to the fact of the case, the corporate debtor was a special purpose vehicle creator to execute a BOT highway project in Maharashtra. To finance the project, it borrowed large sum of about 322 crore in 2010 and another 83 crore and 66 lakhs in 2013. These loans were backed by mortgage, escorts accounts, and personal guarantees by directors. In 2015, the loans were restructured to 414 crore, but the company still defaulted. Its loan account was declared NPA in November 2016, and a revival letter in 2018 acknowledged the outstanding debt. Union Bank issued a recall notice in June 2018 and then filed a Section 7 IBC petition in August 2018. The NCLT Mumbai admitted the petition on 19th of May 2023, starting the CRP. In this case, now my screen is visible, no?
Yeah, your screen is visible.
Yeah. So in this case, there was three issues which was raised. The first issue was that whether CRP admission is mandatory once debt and default are approved. The second issue was that can pending arbitration settlement with GUM shift liability from debtor to state. Does Vidarbha Industries versus Axis Bank allow discretion to deny CRP in such cases? Moving towards the arguments which was made by the party, the appellant, they claimed that after the government of Maharashtra
I think
terminated
this is, 1 minute, your slide is different. It's referring to NCLAT now. Yeah, now it is.
They claim that after the government of Maharashtra terminated the consent agreement 2019, the state became responsible for repaying the lenders. Pointed out that the arbitration was pending against the government, GOM, government of Mumbai, with a claim of 456 crore, and the GOM had often offered a settlement of rupees 174 crores. Argued that this settlement amount was enough to pay Union Bank dues and relied on the Supreme Court case Vidarbha Industries versus Axis Bank of 2022, saying that insolvency admission is discretionary and should not be allowed when substantial recoveries are possible, and also mentioned that an OTS proposal of rupees 128 crore was under negotiation. The respond of this, they said that debt and default were crystal clear and supported by acknowledgement, balance sheets, and the revival letter. The pending arbitration with the government of Mumbai was irrelevant to the bank claim since no money had actually come in. Even if the settlement with GOM happened, rupees 174 crore was far less than the total debt of rupees 824 crore, out of which Union Bank share was over 249 crore. Distinguished Virdhaba Industries, nothing that in the case was enforceable tribunal award existence, while here arbitration was still pending and uncertain. The judgment of the tribunals, the NCLT Mumbai, they admitted the Section 7 petition and initiated a CRP against the corporate debtor. The NCLAT upheld the NCLT admission of CRP. It relied on the Supreme Court precedents like Innovative Industries versus ICCI Bank and ES Krishnamurthy versus Bharat High Tech. The tribunal said that once debt and default are established, admission of a Section 7 petition is mandatory. It rejected the argument that liability shifted to the state, holding that contracts with GOM could not override the company liability to its lender. It also dismissed the reliance on Virdhaba Industries, clarifying that speculative future claim cannot stop insolvency proceedings. Therefore, the appeal was dismissed and CRP against the corporate debtor continued. Moving towards
Here only one point I'll make for everybody's benefit. Vidarbha Industries is not a case you can apply to every situation. When you say a company is solvent, then you cannot admit me to CRP. Then the two questions come up. Why you didn't pay? In Vidarbha, it is a very peculiar case, right? Because of that, when the money comes, they could have easily settled the whole liability. So in decision after decision, they have said Vidarbha is a one-off case. It cannot be just applied generally. The decision is specific to that case. So just because you are solvent and your net worth is positive does not mean that you will go and say that I can pay. Then why you didn't pay? Then you say that why you didn't pay. Or even after, when you could have paid even after the demand notice, why have you not set out your facts clearly saying that why you couldn't pay?
Yeah.
Or you to take a defense. So Vidarbha cannot be quoted gently. Vidarbha is case specific. It is in that context. It has to be understood. That subsequently many judgments have said, but I thought when Vidarbha came up, I thought I'll just let me share this with everybody. Now please continue. Thank you.
Thank you.
Moving towards the next case, which is Trinity Auto Components Ltd versus Axis Bank Ltd, decided by the NCLAT Principal Bench, New Delhi, on 11th of September 2025. This case involves a corporate debtor, Trinity Auto Components Ltd, and its financial creditor, Axis Bank. The dispute arose out of a clear rehabilitation under the BIFR scheme and later resolution under the Insolvency and Bankruptcy Code. Moving towards the fact of the case, the Trinity Auto Component was engaged in manufacturing forged parts of heavy vehicle in 2014 under a BIFR rehabilitation scheme. The company was taken over by a Triani Steels Limited. Axis Bank, the sole secure creditor, was to restructure dues at 12% interest repayable in 48 installments. However, Axis Bank kept charging higher interest around 14.75, that's 16%, though in 2017 it's credited back rupees 118 crore as excess interest, and after SICA was replaced in December 2016, the bank again began charging higher interest, leading to further excess debt of amount 82 lakhs. The company filed for CRP under Section 10 IBC in May 2017, and a resolution plan was approved in January 2018, requiring Axis Bank to give working capital of 7 crore 68 lakh at 12% interest. Later in June 2019, the Axis Bank demanded back the refunded rupees, that was 118 crore, claimed that the BFR scheme had failed. Trinity Auto filed an application before NCLT asking for enforcement of BIFR concession and refund of excess interest. When NCLT only partially allowed the claim, the company appealed to the NCLAT. In this case, 4 issues was raised. The first was that whether the concession granted under the BIFR scheme survived after the approval of the resolution plan under the IBC. The second issue was that whether Axis Bank was liable to refund credit excess interest charged contrary to the BIFR scheme and the resolution plan. Third was that whether Axis Bank could reclaim the rupees 118.46 crore earlier credited to the debtor. The last issue was that whether past claims, that was pre-CRP dues, not included in the resolution plan could be enforced after its approval. Moving towards the argument of both the party, the appellant said that BIFR scheme remained binding even after repeal of SICA and Axis Bank wrongly charged excess interest, so the amount must be refunded. In June 2019, demand for rupees 118.46 crore was illegal since once a resolution plan is approved under section 31 of IBC, it binds all these stakeholders. The respondent, they argued that the BIFR scheme lapsed once CRP began. Once the resolution plan governed rights and obligation, the debtor itself admitted failure of the BIFR scheme in its section 10 application, so it cannot claim benefit from it now. The bank was entitled to reclaim the excess amount credits since BIFR concessions no longer is applied. Moving towards the judgment, the NCLT Mumbai in June 2024 held that the resolution plan was supersede the BIFR scheme, directed Axis Bank to refund only excess interest charged after CRP admission in May 2017, but rejected other claims. The NCLAT, New Delhi on September 2025, they affirmed NCLT's view that BIFR concessions cannot survive after resolution plan, applied the clean slate principle from Ghanshyam Mishra, Isar Steels and Swiss Ribbons. Once the resolution plan is approved, all prior claims stand existing. Since Axis Bank had 96% voting share in the COC, it had the opportunity to raise claims during CRP but did not. It cannot revive them later. Similarly, Trinity Auto cannot seek benefit of BIFR concessions after approval of the resolution plan. The appeal was dismissed with both parties bound strictly by the resolution. Moving towards the next case, which is
one minute. I'll add something here in BIFR. See, let's understand one thing. When the IBC was enacted, the option was given to the corporate debtor to move to IBC within 6 months. Point number 2, we need to understand that, as rightly said, once you are in CRP, it's a proceeding which starts afresh, right? Whatever may be in the status in BIFR. If BIFR had given concessions and it was under implementation stage and there was a failure, then the FC had the right to come to CRP. But when you're going to transfer cases, no decision has been taken. Here in this case, I really don't know where was the failure. After the BIFR scheme was approved and then there was a failure and then this application was filed, I'm not very clear about it, but it appears there was a scheme which was sanctioned and under implementation there was a failure where possibly Axis Bank charged higher interest. That once we see the facts, we will know better. But what is important for us to understand is in all such transfer cases, there are cases where, BIFR was there. BIFR was sanctioned. Subsequently, they came under CRP, whether it was a default or whatever has happened. We need to understand that Supreme Court has clearly said one thing about limitation that we all should know. This is just not a part of this case, but just a part of information. That in BIFR there is a moratorium. Okay, so that period can be completely excluded when you are filing a case under section 7 or 9 in IBC. There is Supreme Court judgment to this effect, and that is very important. Many people have lost out because of that, not taking that moratorium into account. Their applications have been dismissed. So that is something. Now, of course, it doesn't make sense whether the period has gone. But in the initial stages, this happened for many, many applications. They lost out because of that. Yeah, please continue. Thanks.
Thank you.
Moving on towards the next case, which is Rajratan Babulal Agarwal versus State Bank of India, decided by the NCLAT Principal Bench, New Delhi, on 12th of September 2025. This case is between a corporate debtor, Shri Tradeco Dessen Private Limited, and its financial creditor, State Bank of India, SBI. The appeal was filed by the suspended director of the company against the admission of insolvency by NCLT Mumbai. Moving towards the fact of the case, Shri Tricado Dessen Private Limited was engaged in manufacturing maize-based food and industrial product. SBI had begun giving credit facilities since 2012, later enhanced in 2019 to over 105 crore. Due to financial difficulties, the company defaulted and its account was declared NPA on 26th of August 2019, and SBI issued SARFAESI and recalls notice in 2021 demanding dues of over rupees 143 crore. In October 2021, SBI filed a Section 7 IBC application before NCLT Mumbai showing default of rupees 147.86 crore. On 15 February 2023, NCLT admitted the petition, finding that debt and default exceeding rupees 100 crore were established and appointed an IRP. This order was challenged before NCLAT by the suspended director of the company. Moving toward the issue of this case. In this case, there were total 4 issues. The first was that whether SBI had sufficient proved debt and default by the corporate debtor to justify admission under Section 7 IBC, whether the demand of amount and NACL record relied upon by SBI were reliable or defective. Third issue was that whether pendency of proceedings before DRT or LS receivables of the corporate debtor could affect admission under Section 7. The fourth issue was that whether the interim order of NCLAT keeping CRP in abeyance pending settlement talks OTS could impact the validity of NCLT admission orders. Moving towards the arguments made by both the party, the appellant said that SBI failed to consistently prove default. NACL recoveries were only prima facie evidence. Statement of accounts were incomplete with manual corrections, hence unreliable. Theft of company records during earlier CRP prevented proper verification. Balance confirmation in 2020 was obtained under pressure from the bank, and the company had receivable worth rupees 277 crore, which should have been considered. Since DRT proceedings and counterclaims were pending, insolvency should not have been admitted. The respondent, they argued that loans were sanctioned and availed default began in 2019. Accounts were classified as NPA, and NACL default record plus SARFAESI notice plus recall notice showed clear default. Statement of account showed dues above rupees 147 crore. The company itself confirmed dues of rupees 97.28 crore in April 2020 by board resolution, and earlier CRP also admitted SBI claim confirming default. OTS proposals made by the company further admitted default, and pendency of DRT proceeding could not block IBC proceedings, which are independent and special in nature. Moving toward the judgment of the tribunals, the NCLT Mumbai.
Sorry, one question, sorry. So it was the second CRP application made. Earlier there was a CRP application.
It says earlier slide you go that it says that earlier CRP, the second last. No, the same thing. Earlier CRP also admitted SBI.
So, the point is that CRP, what happened? It did not continue, it got closed.
Second slide. Next.
Even in respondent's arguments, they have said that.
Respondent argument, second last argument.
Yeah.
Earlier CRP also admitted SBI's claim. So I think they withdrew and they must be OTS or something maybe.
Something would have happened, we don't know.
Yeah.
The NCLAT, the tribunal held that SBI had clearly proved financial debt and default exceeding rupees 100 crore, and NACL record statements of amount, SARFAESI notice, and balance confirmation together formed strong evidence, and minor correction in account statement did not erase the fact of default. Theft of records on pending DRT proceedings were irrelevant because IBC overrides other remedies. The company owns OTS proposal were treated as acknowledgement of default, and therefore
OTS. So I think then CRP, they must have done this. Let's see.
The company's own OTS proposal were treated as acknowledgement of default. Therefore, NCLT was correct in admitting SBI's Section 7 petition, and the appeal was dismissed. The appeal was dismissed, and CRP was ordered to continue. The interim stay period was excluded from the CRP timeline, and the NCLAT upheld that the debt and default exceeding rupees 100 crore were duly proved, and insolvency admission under Section 7 was valid, and pendency of DRT proceedings or claims of receivables could not stop the CRP process. Moving towards the next case, which is Mansi Brar Fernandes and Sunita Agarwal versus Gayatri Infra Planner Private Limited. And Antriksh Mansi Brar Fernandes versus Subha Sharma and another, decided by the Supreme Court of India on 12th of September 2025. This case is concerning a corporate debtor and home buyer who had filed application under Section 7 of the IBC. The fact of the case is as follows. The appellant Mansi Brar Fernandes and Sunita Agarwal entered into an agreement with the developers. Mansi paid rupees 35 lakh in 2016 for 4 flats with an option for the developer to either buy back at rupees 1 crore within 12 months or hand over the flat, but no possession was given and post-dated check bounced. Agarwal invested rupees 25 lakhs in 2015 and with a promise of 25% annual return under a buyback plan, no construction was ever started, and both moved the NCLT under Section 7 IBC, which initially admitted their petition. However, the NCLAT reversed this, holding that they were speculative investors and not genuine home buyers or financial creditor. The matter reached the Supreme Court. In this case, 3 issues was raised. The first was that whether investors under a buyback or refund agreement qualifies as a financial creditor under Section 5, Clause 8F of IBC. Second issue was that whether can speculative investors trigger CRP meant for genuine home buyers. The third issue was that applicability of 2019 IBC amendment threshold 100 allotments or 10%. Moving towards the argument of both the party, the appellant, they were bona fide home buyers and should be recognized as a financial creditor. The buyback clause were drafted by developers, not them, so speculative intent should not be presumed. Just because there was a buyback option, it should not mean they lacked intent to take possession. And they pointed out that later CRP proceedings against the same developer has already admitted their claim. The respondent, the appellant, in response of this, the respondent argued that the appellant were not looking for a homes but for quick profit with high returns. Their agreements had hallmarks of speculative investment, high interest, buyback clause, and no real construction activity. They relied on the prior urban land case where the Supreme Court had warned against misuse of IBC by speculative investors. Moving to the judgment, the NCLT initially admitted Section 7 petition of the Fernandes and Agarwal. The NCLAT reversed the admission and held appellants were speculative investors and not a genuine home buyer or financial creditor. The judgment of the Supreme Court, the court analyzed the nature of speculative investment in a real estate, and it said that the IBC is not a recovery tool but a mechanism to revive projects and protect genuine stakeholders. It listed indicators of speculation, buyback or refund clause, high assured returns, options of refund instant of possession, and purchase of multiple units. Applying this, the court held that both appellant were speculative investors with no genuine intent to take possession, and their Section 7 petition were rightly dismissed by the NCLAT. On the second issue, the court clarified that the 2019 amendment threshold of 100 home buyers or 10% applied to pending cases as well. Since the appellant did not meet this, their applications were not maintainable. However, because another CRP was already ongoing against the developer, the court allowed the appellant to file claims in the CRP or pursue remedies before RERA or Consumer Forum. The case involves the Supreme Court held that the appellant were speculative investors and not genuine home buyers, and their insolvency proceedings were not maintainable. Moving towards the
Uh,
order of the
just a moment on this case.
This was interesting. Yeah.
See, there are earlier judgments on speculative buying, and there are many judgments in Mumbai court, even NCLAT. See, what we need to understand is that what is speculative buying? Now, just because a huge interest is charged does not mean that it is speculative buying. Speculative buying are largely investors who come in, buy in a project 10 or 15 or 20 flats, not single flat like a home buyer. And they have conditions which says in the agreement that this is the return you are supposed to pay. In case you fail, I will take over the property and the flats or whatever it is. Now that is speculative buying. They are not home buyers. Okay. Now on the same yardstick, which one question I have raised in many forums, is still not decided, is that suppose there is a residential building where corporates come and take a few flats. Now, will that corporate become home buyers in that sense? Technically, they are treated as home buyers. But I wonder how can you do that? Home buyers are very typically, the whole concept of making home buyers a financial creditor is because ordinary citizens, their hard-earned money, they invest in a project, and they want a house which is recognized by Supreme Court also as a right to life under Article 20. Now that is what is the basis on which the advance given by the home buyers are treated as financial debt, and they are made financial creditors. Now, can that logic apply to a corporate debtor? A corporate debtor measured in the same yardstick of a right to life, because it is a fictitious person. See, it's a fiction of law. Corporate debtor is a fiction of law. Any company that is created is a fiction of law. So the basic question is that when you are creating a company as a fiction of law, can you apply the same yardstick to a company for making him a home buyer? It's a basic question. You can say that you cannot differentiate because company is a person who has a right to be sued, can be sued, all the rights of a individual, except that the company cannot marry and it cannot be jailed. You will apply this also to them? It's a question that I have in my mind, which I'm sharing with all of you.
According to me, Mr. Devarajan, first of all, once they invest, we have to see whether it is speculative. If that company is taking the, say, 5 flats under the scheme that they are going to allocate this to their MD, CEO, and because that is pre-decided when they invest in that, it has to follow process that they are going to allocate to their staff or this, then it cannot be said speculative. Then they will be under the same regime of that home buyers. But if the same company has invested multiple for investment purpose, then they will be speculative.
Yeah, I understand. See, I am not even disputing what you're saying. I'm basically saying that is there a case to, make a company a home buyer when they invest? See, the company does not get affected the way a home buyer gets affected when a project comes into difficulty. And the whole amendment was with reference to home buyers who have booked flats and are in trouble in big projects. It was not actually, the change did not come based on the fact that the big companies who invest in flats for their own employees possibly, but they are not affected if the project fails. The employee of the company is not going to be affected. The company is going to be affected. They're going to make a loss with the business risk they have taken.
Yeah.
So that is where I'm coming from. I am not saying that what you're saying is absolutely right. Speculative buying as the method is very different in terms of looking at speculative buying. But this is a question that keeps on coming up when we see a lot of... See, I've had cases where companies have invested 27, 28 flats, right? And they're claiming as home buyers. They've not paid the entire money. A lot of things I've seen. So the point is, I'm just wondering whether they are eligible to be called a home buyer in that sense, even if it is not speculative buying. It's a loud question I'm asking.
Yeah. One of the participants, Miss Pratna said, sir, definition of allottees as per RERA does not make any distinction between corporate entity or.
Yeah, I agree with you. I'm talking with reference to IB. Yes, I fully agree with you. I have no arguments on all that. But in the context of which this has been done,
The
whether a
purpose.
company should also be given such a status. You may say it will be, it will violate Article 14 if you treat them differently. That I agree with you. Because you treat everybody equally in that sense.
Yeah.
Anyway, it's just a thought which I shared.
Yeah,
Nothing
yeah.
to do with the specific case.
Maybe somebody will question that, then it will be decided whether they are actually, when the CD will question whether they are home buyer.
In fact, incidentally, in one of the matters we have questioned, it is pending in NCLAT. Huh?
Okay.
But the settlement is happening, so no decision may come.
Okay.
Yeah. Okay.
Now this disciplinary committee, right? Order of discipline.
Yes,
Okay.
yes.
Yeah.
So by this case, we have come to the end of the judgment of the tribunals. Now moving forward with the orders of the disciplinary committee. So the first case is that Insolvency and Bankruptcy Board of India versus the RP. This case was decided by the disciplinary committee on 20th of August 2025. The case is not about the corporate debtor or an operational creditor. It relates to the professional conduct of an RP in the CRP of Ocean Water Umbrella Private Limited. Moving towards the fact of the case, which is Mr. The RP in July 2022. The RP in July 2022, after NCLT Chennai admitted a Section 7 application. A complaint was later filed against his conduct during the CRP, leading to an investment by IBBI. The investigation found two major lapses. The first was that failure to safeguard asset. Valuation during CRP showed asset worth more than 3 crore, but during liquidation, asset left were worth only about rupees 60 lakhs. Security agencies were appointed, but there was no proper verification, documentation, or police action despite repeated theft and vandalism. The second was that defective liquidation application. The RP filed the liquidation applicant in March 2023 without COC resolution under Regulation 39B and 39C, which are mandatory. This mistake led to a 6-month delay as NCLT had to send the matter back for a proper resolution. Moving towards the issue of this case. In this case, there were 4 issues. First was that whether the RP failed to preserve and protect asset of the corporate debtor as required under Section 25 Clause 1 of IBC. Second, whether the RP was justified in fortifying procedural compliance under Regulation 39B and 39C when filing liquidation application. Third was that whether lack of cooperation from COC absolves the RP of his statutory obligation. And the last issue was whether the conduct of RP amounted to professional misconduct under Section 208 Clause 2A and E of the IBC Code. Moving towards the arguments in defense, the RP, he said he had taken steps like appointing security agencies, even paying from his own pocket since the COC did not release fund. Claimed theft was exaggerated and the assets might have just been relocated within the premise. Alleged that complaint was retaliated by Union Bank of India, the sole COC member. And on liquidation, he argued he had informed the COC about the requirement, but since they did not cooperate and he had to follow their instruction and file the application anyway. Moving towards the findings of the IBB, as an RP, his role is visionary and demands a high standard of care. He did not conduct periodic checks, did not document handovers, and failed to involve law enforcement despite theft. Filing a defective liquidation application showed negligence. He should have assured compliance with the law and not simply followed COC direction. The judgment of the disciplinary committee was RP was held guilty of gross negligence and professional misconduct. He violated Section 25 Clause 1 and 208 Clause 2 of the Code and Regulation 7 Clause 2 of IP regulation along with multiple clause of the Code of Conduct. The disciplinary committee rejected his defense and concluded that he failed both in protecting assets and in complying with the statutory requirements. the disciplinary committee ordered suspension of RP authorization for assessment for 6 months. This suspension will take effect after 30 days, and copies of the order were sent to his professional institute, all COCs where he is working, and the registrar of NCLT Principal Bench, New Delhi. This case of professional misconduct, but this case was, in short, this case is a professional misconduct by a resolutional professional. Moving towards the next case, which is about Insolvency
Pardon?
and Bankruptcy Board of.
1 minute. May I say something? Devang, this
Yes.
particular participants are all RPs, or what is the composition? Any idea? Yeah. You have any idea the composition of people who are participating are RPs, or how? What is it? Any idea?
Maybe few RP, I don't know.
No, I just wanted to know, because see, what I am saying is that we as RPs in our profession is beaten from all sides.
Ah,
Okay, and basically one thing that we have to ensure is that we follow the process to the T. We should not be bothered what the COC says. COC cannot give you, command you, because one basic distinction which the RP should also IP should understand, and the COC also should understand, is that the IP is the boss of the company when he's appointed as an IRP or an RP. The entire board powers are transferred to him for managing the company. COC has no say in that in terms of operations. The Act very clearly says that the RP is subjected to the restrictions of the board in these matters. So IBBI are the only authority to put some restrictions on how he is going to govern the company. Let us understand the creditor control business very differently. The COC is not the board of directors. We need to understand that very clearly. The COC never managed the company even before it entered into CRP, and members of the COC are not competent to run a company. Maybe RP also may not be competent, that's a different issue. But the RP has been given the job to manage a company. The second issue that we need to be very clear is that COC has to only decide on matters that is coming before it under section 28 and other places where they have to vote by majority. It says all decisions of COC has to be taken by a simple majority of 51. Now, it is for the RP to decide what are the decisions COC has to take, what is the decision he has to take. This basic distinction every IP should understand. Now here he says that I filed the liquidation application because the COC told me. The COC may have told him, it is his responsibility to say, this is what the regulation says, and I cannot file any of the applications without complying with 39B and 39C. So I need to present the liquidation cost, how it will be met, and also ask the COC in consultation and decide whether it can be sold as a going concern and take a decision on that, accordingly recommend the liquidation. He cannot say, even if it is pressurized by COC, that is not a defense, because he has to do his job as per the regulation. So all IP should understand one thing, their primary job is to follow the regulation to the T. Second, in management of the company's affairs, you don't have to involve the COC. You take something to the COC which you're not required to take, and subsequently COC says something and you don't do it, then you are putting yourself in a difficult situation. I have also seen many of our IP's friends taking claim matters to COC. Claim matters is something you have to decide. COC has no role. The reason is that COC is a conflicted party. Because the more the claim is admitted, each FC will say, boss, my share will reduce. So we should understand that COC is a conflicted party. You cannot take claim matters to this. You're only supposed to place the LOC, the list of creditors before the COC. That is your only job.
and you have to inform the change in the claim amount, and these are.
That is fine. That when you file, when you place it before the list of creditors, in every meeting, if there are any changes when you update the claims, that is always available.
That's
So-
only a matter of information.
Yes.
Yeah, that you
So,
will put this many
Now,
claims.
now these things happen basically because the RP doesn't realize this, and he gets into situations like this. Okay. Now, asset security, custody and control of assets is your primary job. Now, I have put security. Then, of course, if there is a theft, you're supposed. Have you reported a theft? Have you gone to the police station, filed a complaint? I'm sure he had no answers to all this. That is why he got into a situation like this. Yeah, sorry. I just wanted to share this. Please go ahead.
So it is a case relating to the professional conduct of a liquidator during the liquidation of Jaipur Sugar Company Limited. Moving toward the fact of the case, the CRP of Jaipur Sugar Company Limited was initiated by NCLT Chennai on 25th of February 2019 and later liquidation was ordered in May 2020. RP was appointed, liquidator was appointed in July 2022. During liquidation, a company called Kineta Global Limited proposed a scheme under Section 230 of the Companies Act and deposited an earnest money deposit of rupees 2 crore. Later, disputes arose over valuation of land and NCLT annulled the scheme process. Kineta appealed before NCLAT, which led to delay. After taking charges, the liquidator fortified the rupees 2 crore EMD, saying Kineta appeals delayed the process and caused liquidation costs. Kineta asked for refund or adjustment of the EMD. NCLT on 2nd May 2025 held that Fortufer was wrong and directed refund. Grievances were then filed before IBBI, leading to disciplinary proceeding against the liquidator. Moving towards the issue of this case. This case involves four issues. First, whether the liquidator was justified in fortified the EMD of rupees 2 crore beyond stipulated process condition. Second, whether regulation 2B clause 3 of liquidation regulation could authorize appropriation of EMD towards liquidation cost. Third, whether statutory appeal by the Kineta Global Limited could be treated as default withdrawal justifying forfeiture. Fourth, whether liquidator conduct amount to professional misconduct under IBC and IP regulation. Moving towards the argument made by the liquidator, he claimed fortified was justified because Kineta appeal caused a delay of 2.5 years and heavy cost of about 7.7 crore, relied on regulation 2B clause 3 saying scheme proponents must bear cost of failed process, said he acted bona fide based on legal advice in the interest of stakeholder. The IBB, they made argument the process document clearly said EMD could be fortified only if the successful bidder or defaulted or withdraw. Filing an appeal in a statutory right, not a default or withdrawal. Regulation 2B clause 3 cannot be used to override the process terms. And since NCLT itself has already ruled forfeiture was beyond terms, the liquidator action was contrary to law. Moving towards the judgment, the NCLT held reasonable and beyond process terms directed reform adjustment of EMD to Kineta Global. The disciplinary committee held that forfeiture of EMD must follow the process document. Since Kineta had neither defaulted nor withdrawn, the forfeiture was not justified. Statutory appeals cannot be treated as default, and regulation 2B clause 3 does not allow unilateral of deposit. The liquidator acted beyond his authority and violated provisions of the IBC, liquidation regulation, IP regulation, and the code of the conduct. The registration of the liquidator as an insolvency professional was suspended for 1 year under Section 220 of the IBC, and the order will take effect after 30 days, and the copy of the order was sent to his professional institute and all the stakeholder committees where he was engaged. Thank you. By this, we come to the end of today's presentation from my side.
One question I have here. If you read 2B3, it says any cost incurred by the liquidator in relation to a compromise or arrangement shall be borne by the corporate debtor. Right? He is in charge of the corporate debtor. Where such compromise or arrangement is sanctioned by the tribunal under subsection 6 of 230. So if there is a sanction, then it will be borne by the corporate debtor. Here it is not sanctioned. Okay. Then it says provided that such cost shall be borne by the parties who proposed compromise or arrangement, where such compromise or arrangement is not sanctioned by the tribunal. So the basic question as far as the IP is concerned, the IP adjusted that from the EM. The right course of action for the IP should have been to possibly tell the company that it is for you to bear this because this has not been sanctioned. Huh? Now, when IBBI is saying that forfeiture of EMD is not as per process documents, the process, and I think somewhere if you see, he has said, he is saying that relied on regulation 2B3 and Jainara and Gupta versus some particular, decision he is referring to.
Right.
See, 2B3 has a provision to recover it from the compromise applicant. Now, in this case, despite that, why order has been passed against him is I don't know. There is something in the facts we are missing, or something is there you can check out. Because now, whether you recover that from the EMD and give the balance, or you take it from him, is not a material, default by the IP in the process. So what he could have done is that written to them and said, this money you're supposed to bear. He may say, I've gone in appeal, you wait. But how do I meet my cost? Then he should have gone to SEC and say, boss, I need to meet my cost, you guys contribute. I think these could be the issues that we need to be very careful about.
Process, I think. Even though he can recover, he cannot adjust.
Yeah, see, the point is, you could write to the company and say, this I have to recover this as per this provision, I am adjusting, is it okay? One mail would have saved him, Small things, but interesting, because I suddenly thought there is a gap here in terms of this particular aspect.
So he has to bear the cost in this case.
No, there is very clear provision under the liquidation regulation in terms of the contribution by the FCs for purpose of meeting liquidation cost. So liquidation cost was there, and this matter is under appeal. The liquidators should have gone to the FCs who are supposed to contribute and say, boss, this is my cost, you are supposed to contribute, please contribute. The matter is under appeal. I can't now recover it. That should have been the approach in that sense.
May have to be refunded at a later date.
No, a later date, if suppose the compromise was not, approved, then the person who proposed the compromise has to pay the cost. It could have been recovered at that point of time by adjusting the EMD, by telling him, this is what I'll refund. Now its finality is attained, your compromise is not accepted, now you have to pay this. I will deduct and say, and record that in the SEC meeting and do it. And finish it off. That would have been easier for him.
Verification was required.
Again, finer details of the process not being followed is what has put him in trouble.
That's all, I think. But there is one question, Mr. Devarajan.
Yeah.
What are your views on one of the COC member asking for claim forms of another creditor, new claim received? Is the RP entitled?
No, you are not supposed to give.
No,
You're not supposed to give.
Many RPs have given under pressure. In fact, I will tell you a very good example. In one of my matters, there was an application demanding the copy of the claim form made by the opposite party. Because when I had given the answer, I had not given the claim form in my reply. So the court asked me what is to be done, NCLT. I told them that I am not supposed to give I am not supposed to share the claim form. Under, I think, regulation 13 and 14, my job is to only list of creditors.
Admit or not admit.
List of creditors, finished. And I said, the claim form, if I am supposed to give, if you give me direction, I will give the claim form. Because the matter was there before the court and he was asking for the claim form to substantiate something. The court, after deliberation, said, no, you don't give the claim form.
Because you are giving them the documents.
Yes, even though the matter was in court, he said to the opposite party, you need not share the claim form.
Great.
So, many a times we make a mistake by in our application put the claim form of the party, which is also not correct because the moment it goes to court, the proceeding in rem. You
Yeah.
can give the claim form if the court directs you to give a claim form to somebody for X or Y, Z reasons. In my case, the court said don't give. You need not give.
Because if the claim amount is in a dispute, then that claim form, if court directs, then only give. Otherwise, other party.
No, see, if the claim amount is in dispute, the RP knows what is claimed, the creditor knows what he has claimed. So I think
Yeah.
there is no dispute there. The dispute is the amount admitted or the amount rejected.
Yeah.
That could be the dispute. There is no other dispute in
Ah.
that sense. And once I have seen that if you, in your notes, you clearly give the reason for why you have not admitted, then life is much easier.
Yeah, you have to give reason. It should be clear.
You have to inform the claimant why the claim has
you
not
have
been
to.
accepted.
You have to send a mail to the claimant. Because his right to appeal is there, no?
Yeah.
How will he
But
appeal unless he knows?
Without reasons.
Another COC member can't ask for it.
No COC member can ask for it. But in many cases, the RPs have been pressurized, I know personally, and they have given the forms informally to the COC members. The basic issue, Devang, that comes there is that RP says, boss, if I don't give it to him, he'll replace me. He has majority. Now, this profession is, you should say, you live by the day. You are there as an RP today, you may not be there as an RP tomorrow. So,
And mostly this are asked orally, no written communication is there. So it makes things more tough.
no, but the point is you ask orally, you send it through some means, somebody knows you have sent it to them. If they make an issue out of it, you are in trouble. But the point
Yeah.
is that why can't you say you are a conflicted party, I will not share the claim form with you?
Yeah.
Record that also in mail. See, what we don't do is that we don't record it in mail.
Yeah.
ओरली पूछता है, ओरली जवाब देते हैं, बाद में प्रेशराइज करेगा और 2 बार आप रिकॉर्ड करो मेल में, तीसरी बार वो पूछेगा ही नहीं कुछ आपसे. After that he replaces you, tell the court this is all what has happened before he replaced me.
Yeah.
You have a right to being replaced. You can ask them why I'm being replaced. You can appeal against that
No,
also.
no. See, the point is if a replacement is because of fraud or it is basically because the COC is inconvenienced because you follow the process, then of course there is a
Then
case.
you have a
In
right.
many cases, there are cases where the courts have not allowed the RP to be replaced. There are many cases.
I think yes, with this, I think no more questions. We can close this session. Yeah. Thanks a lot. Thanks a lot.
Thank you.
Welcome,
Thank
welcome,
you.
welcome. Bye.
People are also thanking you, Mr. Devarajan. Thank you.
You're welcome, welcome. Anytime.
Thank you.
Thank you. Bye.
Thanks from all participants. Thanks a lot.
Thank you.
See you all again. Thanks
Bye.
for your participation. Thank you.
Yeah.